That's what his name was Stewart. I can't remember.
I now call the meeting for the special magistrate to order. Please stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome to the Hillsborough County Code Enforcement Special Magistrate hearing. When addressing the magistrate, please state your name, address, and speak clearly into the microphone. If you're planning to speak during this hearing, you must sign the speakers list located at the front door so your name can be called. Any person who decides to appeal a decision of the Code Enforcement Special Magistrate will need a record of the proceedings. The record is comprised of testimony and evidence upon which an appeal is based. It is your responsibility to ensure that a verbatim record of the proceedings is made. By law, you have 30 days from the date of my order to appeal my decision to circuit court. Presentations by the county, respondents, and opposition must be kept to a maximum of 10 minutes each. The magistrate may recess at any time to conclude and reconvene at any time to conclude its business as needed. The basic process for this hearing is as follows. Ms. Meyer will conduct the oath of witness, and your case will be announced. Staff will present their evidence on your case, and then you'll be allowed to rebut that evidence and explain what has occurred. I'll close the hearing and announce a decision. I may ask questions and allow other witness testimony if necessary. Depending on my order, county staff may later have to conduct an inspection to see if you've complied. If the staff believes you have not complied, you'll receive a notice in the mail. By law, you have 10 days to contest that notice, otherwise it will be considered correct and a lien may be filed against your property. For false alarm or water resource cases, if you have not complied by paying the past due burglar false alarm fine or water resource penalty fine within the time ordered, you will receive a notice in the mail. By law, you have 10 days to contest that notice, otherwise it will be considered correct and a lien may be filed against your property. If you have any questions, these rules are outlined by Hillsborough County Codes of Ordinances and Laws, Chapter 14, Article 2, Section 14. And before we begin, please silence all electronic devices. First order of business, I approve the meeting's minutes for March 10th, 2023. And now we're ready to administer the oath. We're ready.
All county staff who will testify must take the oath of witness. Please stand and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please, first case, please.
First case is on page 2 of the agenda under burglar alarm cases. Number 1, BA 1000004A. This case complied May 5th, 2023. Number 2, BA 103545. Complied May 11, 2023. Number 3, BA 123328. The owner is the John E. Hanson Life Estate, 1936 Wolf Laurel Drive. We have service and no one is present.
Tina Birding, Compliance, Communities, and Conservation. Case BA 123328, data false alarm 8/20/22, 91/22, amount due $150, no additional outstanding violations.
I rule in case BA 123328 that based on the evidence presented, I find the violator has failed to pay the false alarm penalty fine imposed by County Ordinance 04-16. I grant the violator 30 days to pay the fine imposed. Order if payment is not made by that date, a fine of $20 per day be assessed.
Page 3, number 4, BA 124982. The owner is Jessica St. Fleur, 4242 Unbridled Song Drive. We have service and no one is present.
Case BA 124982, data false alarm 9/24/22, amount due $100, no additional outstanding violations.
I rule in case BA 124982 that based on the evidence presented, the violator has failed to pay the false alarm penalty fine imposed by County Ordinance 04-16. I grant the violator 30 days to pay the fine imposed. Order if payment is not made by that date, a fine of $15 per calendar day be assessed.
Number 5, BA 102691. The owner is 2017-2 IH Borrower LP, and the violator is Christina Reyes. Location 10507 Goshawk Place, we have service and no one is present.
Case BA 102691, date of false alarm 10/4/22, amount due $75, no additional outstanding violations.
I rule in case BA 102691 that based on the evidence presented, the violator has failed to pay the false alarm penalty fine imposed by County Ordinance 04-16. Grant the violator 30 days to pay the fine imposed, order if payment is not made by that date, a fine of $15 per calendar day be assessed.
Number 6, BA 126437. This case complied May 11th, 2023. That concludes the false alarm cases. Page 5, under water ordinance cases, number 7, WR 2202721. The owner is Tylando D. Tobias and Tony B. Tobias, 13904 Snowy Plover Lane. We have service and no one is present.
Good afternoon, David Kanzler, Hillsborough County Code Enforcement. On Wednesday, 7 December 22 at 6:22 in the morning, Officer Baker arrived at 13904 Snowy Plover Lane to observe the sprinkler system in the front yard running. The assigned watering days are Wednesdays only. This was a Wednesday, but the watering hours are from 8:30 to 12 and from 6 p.m. to midnight, 11:59. This is a violation of the county water ordinance for watering during non-watering hours. This location is south of the Alafia River, and this is the third offense for this location. The notice of a violation was issued on the 9th of December 22. It went into default in January 17th of 23, and the notice of hearing was posted the 3rd of May of 23. For the history of this property, in August of 22, case number WR 2201992 was issued a warning. In September, a fine was issued. It was unpaid for $100. Now it has a balance of $850 with additional fines running. And today's fine is $200.
I rule in case WR 2202721 that based on the evidence presented, the violator has failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7, Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. Based on the violator's history, I grant the violator 15 days to pay the water penalty fine imposed. Or if payment is not made by that date, a fine of $30 per calendar day be assessed. Next case, please.
Number 8, WR 2202723. This case is closed. Number 9, WR 2202789. The owner is Vincent T. Faris and Sharon B. Faris, 16232 Breckenmore Lane. We have service and no one is present.
Just wait for the image to load. Would you like to see a dark image of some water on a driveway?
Goodness,
All right.
that's tough.
It's terrible. Good afternoon, David Kanzler, Hillsborough County Code Enforcement. On Wednesday, 28 December of 22, at 06:11 in the morning, Officer Franco arrived at 16232 Breckenmore Lane to observe the sprinkler system operating in the front yard. Assigned watering days are Mondays and Thursdays. Watering hours are between 8:30 a.m. and 12 noon and 6 p.m. to 11:59 p.m. This is a violation of watering on a restricted day and watering during restricted hours. This is the second offense for this location. The notice of violation was issued on the 28th of December 22. It went into default on the 31st of January 23. Notice of hearing was noticed by certified mail on March 31st of 23. The history of this property is in November of 22, WR 2202645 was issued a warning for watering outside of hours. The fine on this case is $100.
I rule in case WR 2202789 that based on the evidence presented, the violator has failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7, Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. Grant the violator 30 days to pay the water penalty fine imposed, order of payment is not made by that date, a fine of $20 per calendar day be assessed.
And that concludes the water cases.
Absolutely. Thank you. Have a great weekend.
Next case is on page 7, under landscaping and natural resource cases, number 13, case number L227736. The owner is Wendy L. Morrison. Location 10710 Dalton Avenue. We have service and we have an individual online virtually to testify.
Okay.
If you're, good afternoon, sir. Raise your right hand, please. Do you swear or affirm the where'd you go? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name and address.
My name's Shane Hodges. I live at 10710 Dalton Avenue. The address in question, Tampa, Florida 33615.
Thank you.
That's what happened. Mr. Hodges, we're just waiting on the computer here. Give us 1 second.
Oh, no problem. No rush. No rush.
Mine's pulled up. Maybe stop sharing and reshare. There you go. Okay. Come on. It's on our end.
To proceed.
Sir, can you see the screen and the case number?
The case L227736.
Okay, I just want to make sure you can see it. We've got a
Yes,
couple
okay.
monitors here on our end that can't. I just want to make sure you're able to see
Yeah,
it.
I can see it.
Okay, excellent. Then we'll go ahead and proceed.
Okay. John Beavers, Environmental Investigations Supervisor with the Natural Resources Unit of Development Services. In this case, L227736, owner violator Wendy L. Morrison, violation address 10710 Dalton Ave, Tampa, violation observed, unpermitted removal of a 27-inch DBH diameter breast type laurel oak. This property is in violation for 27 inches of tree replacement, donation, or pay $1,755 to the restoration fund. Violation, ordinance violated. Section 4.001, first inspection December 15th, 2022. First notice December 15th, 2022. Last inspection April 24th, 2023. Go ahead. Just gotta roll it. I'll turn this over to Inspector Doyen.
Wayne Doyen, Hillsborough County Natural Resources. On December 15, 2022, I got a complaint at this address in question about unpermitted tree removal. I made contact that day, explained what happened. They gave me tree company's information, but unfortunately I made multiple attempts to try to track down this tree company, and I could not get good service to them. So on that day I did measure, it turned out to be a 27-inch DBH laurel oak tree that was removed. Next slide. On April 24th, 2023, I did my recheck. There was no new shade trees replanted. And that is why we're here today.
So staff recommendations on L227736. Plant, donate 27 inches DBH of approved shade restoration trees or contribute $1,755 to the restoration fund, or a combination of plantings, donations, and contribution to the fund within 90 calendar days. Trees must be 1 inch DBH or larger, a minimum 8 feet in height, Florida grade number 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per DBH inch. The owner will be responsible for this violation. Fines will be issued for failure to meet timeframes.
Okay, Mr. Hodges, what would you like to add?
Well, she wanted me to read the email, but I don't know if I should just read off what she wrote for you guys, or is that?
Well, the email's been submitted as evidence in the case. I have a copy of it here.
Okay.
You're welcome to read it if you want to, but if you want to summarize what the issue is, and then I guess my follow-up question that would be, what is your plan for resolution in this case?
Well, I don't have I'm not involved in the resolution. I'm just representing her. I'm not sure on that end.
You're just the messenger.
Yeah, I'm just the messenger. It's the whole thing.
Okay.
So all I can say is she thought she was in the right by hiring a tree company through Angie's List, and we assumed improperly that those were vetted vendors, and he didn't get anything right. I don't really know what else to say.
Sure. So do you know is it your mother?
Yeah, it's my mother.
Okay. Do you know what your mother's plan is in regards to the options given to her by the staff's recommendation? Does she plan on replanting some trees and then contributing to the fund, or just to the fund itself, or are you going to plant 27 inches of trees, or what's the plan moving forward, and how much time do you think you need to complete that?
I think she was hoping that some of the fine would be mitigated, but beyond that, she plans, I guess, to pay whatever you guys decide. Beyond that, I just don't really have an answer. Sorry.
Okay. I mean, I understand the frustration with hiring somebody that turned out to be a little shadier than you anticipated, but ultimately at the end of the day, it is the responsibility of the homeowner to deal with this particular issue. I wish you would have found somebody different that would have taken better care of you. So I don't feel like there's an opportunity for us to adjust the fine or the inches of trees that could be replanted here. I can give you some additional time to get it completed. But ultimately, at the end of the day, she'd have the opportunity to either plant up to 27 inches DVH of approved shade restoration trees, or contribute $17.55 to the fund, or a combination thereof if she wanted to plant some trees and contribute to the fund. But at the end of the day, we lost a tree here. So we've got to find a way to get us back to center. So.
Okay. Well, that's it then.
Okay. So do you need some extra time to get it done?
Probably.
Or can you do it within the 90 days?
I will speak to her today. I assume she's going to need more time, if that's
okay. All right. Wayne, John, any concern with giving them an extra 30 days here?
No, sir.
Okay. Wayne, same? Okay. All right. Well, what I'll do is I'll amend those staff's recommendations to 120 days to give you some extra time to get that through. I did read her email. It sounded like you had to go fishing for some pieces of the tree.
Yeah.
So I'm sure there was an expense there as well. So
Yeah.
hopefully this will give you some extra time to get that done. And like I said, you'll get some information in the mail in regards to this. Just make sure that you get it completed in the hunt, either making the contribution or the planting. They'll come back out, they'll re-inspect and confirm, and then you're in good shape. Otherwise, fines will start. Okay?
Understood.
Okay. All right. Then I will go ahead and make my ruling.
Okay.
Thanks, Shane, for coming on today. I appreciate it. I rule in case L227736 that based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the gravity of the violation, the actions taken by the violator and the violator's history, I concur with staff's recommendations to require the violator to plant or donate 27 inches DBH of approved shade restoration trees or contribute $17.55 to the restoration fund or combination of plantings/donations and contribution to the fund within 120 calendar days. Trees must be 1 inch DBH or larger, a minimum of 8 feet in height, Florida grade 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per DBH inch. The owner will be responsible for this violation. Failure to meet any of the timelines listed above will result in a daily fine of $150 per calendar day. Good. Next case, please.
Next case is on page 8, number 14, case number L227740. The owner is Stellar Sellers LLC. Location 8002 Fur Drive. We have service and someone has signed in for this case.
Good afternoon.
Right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And state your name and address.
Lamar White, 3213 East 9th Avenue, Tampa, Florida, 33605.
And I have down that you're the owner of
Correct.
this company. Okay, thank you.
I got the document in the mail. So I'm here. I never had to go through any of this
Gotcha.
before.
No problem. We'll walk you through it. The gentlemen are going to give their summary of the case first, and then I'll give you a chance to respond to it. Okay? Oh, let me get my own screen this time.
John Beavers, Environmental Investigation Supervisor with the Natural Resources Unit of Hillsborough County, L227740. Owner violator, Stellar Sellers LLC, violation address, 8002 Fur Drive, Tampa, folio 048665. Folio observed, violation observed, unpermitted removal of one 28-inch DBH oak tree. Ordinance violated, section 4.01, first inspection December 27th, 2022. First notice December 27, 2022. Last inspection March 22nd, 2023. Inspections conducted to. Photo on the left was a Google image from 2018. My initial investigation inspection was on December 27th, showing the laurel oak in the front yard had been removed. Oh. Got it? Okay. Follow-up inspection was held March 22nd, 2023, doing some improvements on the house. However, the tree, no restoration, no corrective actions had been taken. Got it. In L227740, staff recommendation, plant, donate 28 inches DBH of approved shade restoration trees or contribute $1,820 to the restoration fund, or a combination of plantings, donations, and contribution to the fund within 90 calendar days. Trees must be 1 inch DBH or larger, a minimum of 8 feet in height, Florida grade number 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per inch. The owner will be responsible for this violation. Fines will be issued for failure to meet timeframes.
Excellent. Okay, Mr. White, what'd you like to add?
Anyway, I can see the photos from 2018.
Absolutely.
I just purchased the house in September, so I don't
Sure.
know.
Can we bring the pictures back up, please? Fingers crossed.
I only asked because the
Oh. That's not on that one.
yeah, it didn't go up there. I don't know if it was supposed to go there.
Do you have it on your computer, Ricardo? Oh, great, thank you.
I can look at it later.
So the picture on the left.
I
Yeah,
have a photo. All right. Just a little background of what's going on. Purchased the house for a flip back in September. Got into bed with a bad contractor. This is why I'm here. He says I'll take care of it. Okay. And then had a squatter. He ended up squatting, threatening me. I'm in legal, all kind of stuff. He actually left today though, so I just got back from changing the lock.
Well, that's
so-
good.
Getting a step in the right direction, but I wasn't aware of any of this. I just got served, with the violation, so I'm here. I thought it was like a DMV type of thing. I didn't expect to be in front of you guys, so I'm in work clothes and stuff. But,
No worries.
Nevertheless, I have a photo from 2018. It looks like the tree was struck by lightning. I mean, not 2018, from when I bought the house. I mean, I don't know if I could present that, but either way, it wasn't permitted.
You have
We
a
cut it.
picture of that being struck by lightning?
Yeah.
Is it on your phone?
Yeah.
Oh, here comes my famous line then. If it's on your phone, I get to, you give it to the ladies and I get to keep it because we have to
Keep
submit it as evidence.
Can I
Yeah.
send it as a text message?
No, unfortunately not. No,
Okay.
one of these days I'm going to get a nice phone out of this, but nobody seems to want to do it after I tell them that.
I mean,
so.
it might be cheaper to get a new phone to pay this violation.
No, that's a fact. Yeah, I mean, unfortunately,
I got you.
it is what it is,
Yeah,
whether it
it's
was
same
struck by
situation
lightning
like
or
the
not.
last
So,
guy, I guess.
yeah, it sounds like timing is kind of biting you a little bit on it.
Yeah, I'm kind of strapped also because dealing with the eviction and the legal proceedings with all this. I'm looking to put the house for sale on Monday, finally, now that I got him out of there. So looking to hopefully have it closed within 30 to 45 days.
Gotcha.
So just looking to get an extension. Maybe
Well, try not to pass this problem on to the next folks.
Oh, no. I'm going to, I don't know how to go about paying it. I don't know if once I have.
So basically, you're going to get a notice, so it's going to give you the options that they listed as their recommendations. You have an opportunity to either plant 28 inches DBH worth of trees back on the property someplace, or
Not gonna
you can do a portion of that. If you were like, oh, I'm going to plant 10 1-inch trees or whatever, and I'm going to put some in the backyard, I'm going to sprinkle around, then that would be deducted from what's due, obviously, and then you could just pay the
Well,
the fine and the balance
The
of it,
guy
so.
that's responsible for all this was also a business partner too, so
Uh-oh.
this is coming out of his profit.
Well,
So let's do the whole thing.
Either way, you can do it. Yeah.
It
So.
could be that way, but
Yeah. So, I mean, the cost is 1820. That goes into the fund, helps us put up trees in other places. So
Yeah.
it still offsets it. So that's the good news.
Yeah.
And then I understand that you've got some issues going on. You were sitting in the audience when I went through the last one. So if you need some extra time getting that completed, I don't have a problem giving you another 30 days to do 120 days to get that done.
that works.
And then that gives you an extra 30 days to get that money out of your business partner. So.
Okay. And then you said, I guess it's just gonna be mailed to me, how to submit the.
Correct.
Yeah.
After this meeting, you'll get, it'll come in the mail to you
Fine.
with the options, where to go, who to write it to, all that kind of stuff.
As soon as the house
Yeah.
closes, I'll take care
But
of it.
if you aren't gonna, go through the process of planting extra trees, do you really need 120 days versus 90? I don't know, but
It's just
I'll
whenever
give
the
them to
house
you.
sells, as soon as I get that money
Yeah.
in the account,
I'll give them to you, but if it comes sooner, then,
I got
set it off sooner. So that'd be great.
I understand.
Okay. Any questions about that?
Nope.
Okay.
Thank
Makes
you.
sense. I appreciate
Have a
you
good day, guys.
coming down in short order. Thank you very much. I rule in case L227740, the basin units presented, I find the property is in violation of Hillsborough County codes and ordinances listed in staff's presentation. Further, based on the gravity of the violation, the actions taken by the violator and the violator's history, I concur with staff's recommendations and require the violator to plant, donate 28 inches DBH of approved shade restoration trees, or contribute $1,820 to the restoration fund, or a combination of plantings/donations and contribution to the fund within 120 calendar days. Trees must be 1-inch DBH or larger, a minimum of 8 feet in height, Florida grade 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per DBH inch. The owner will be responsible for this violation. Failure to meet the timelines listed above will result in a daily fine of $150 per calendar day. Next case, please.
Next case is number 15, L227747. The owner is Animal Coalition of Tampa Incorporated, 8501 Ladue Lane. We have service, and we do have someone here for this case.
Oh, okay.
Oh, I thought it was a.
Complaining party is here.
Hmm?
The complainant is here.
Okay, that's all I've got.
Okay.
So did you want to testify, or are you just here to see what
Gentlemen, you have
happens?
things that,
Probably want to testify after I hear the.
okay. If you can come up and she can swear you, and then we'll go from there.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name and address.
Ernest Mueller of Mueller Law, PA, PO Box 272071, Tampa,
Okay.
Florida 33688.
And you're here as a complainant and not necessarily representing anyone as an
Not representing
attorney?
The violator,
Okay.
no, I'm here on behalf of the neighboring properties who are the
Thank you.
Excellent. Thank you, Counselor.
John Beavers, Environmental Investigation Supervisor with the Natural Resources Unit. This is L227747. Owner violator, Animal Coalition of Tampa, Inc. Violation address 8501 North Ladue Lane, Tampa. Violations observed. Unpermitted land alterations of a new parking area in the back of the property. They have brought in fill, rocks, asphalt to construct this parking area with a portion off of their property and onto adjacent property. Unpermitted parking spaces per the Land Development Code. Ordinance violated Section 4.01 of the LDC. First inspection, December 27, 2022. First notice, December 29th, 2022. Last inspection, April 24th, 2023. Inspections conducted 3. I'll turn this over to the investigations officer, Wayne Doyen.
Wayne Doyen, Hillsborough County Natural Resources. So I've received this complaint. I made my way out there for my inspection on December 27, 2022. The back of the property for the Animal Coalition, I noticed that they have constructed 4 new parking spaces. They raised it up, rocks, asphalt. And at that time, after looking at the site plans, you can go to the next one, John. So this is the Animal Coalition. The blue line is the building. The red line is the property line. As you can see in the bottom, the south region, the red line, the yellow line is the area of unpermitted land alteration, the new parking spaces. As you can see with the yellow highlighting is where they built this parking area on public land. So it stretches off of their property. Good 14, 17 feet. Next slide. April 24, 2023, I did do a recheck of the property. Still remains the same, all materials. Next slide. Other issues with this facility is they created parking spaces on the sidewalk, which do not, parking spaces aren't to code, and they're not to their original design when this building was built. With these parking spaces here, next slide. 2 more additional parking spaces were added that were not on the original design, so they're not to their permit. Next slide. This area was on the original aerials that I could find. Unfortunately, back when this was built, it was before the new code. But these parking spaces have lost their lines over the years, so they're not properly marked, and they need to restore this back to the original design. Next slide. And again, on April 24th, I did my recheck and everything remained the same. Next slide. Recommendations. Go ahead.
Good. Staff recommendation. Remove all fill material, gravel, unpermitted asphalt on the impacted public lands and restore folio 024168-0220 to the approved commercial construction plans, including removal of 8 parking spaces and properly mark original spaces within 90 calendar days. Or Part 1, submit commercial construction plans and remove all fill material, gravel, unpermitted asphalt on the impacted public lands within 90 calendar days. Part 2, obtain a permit and complete work within 210 calendar days. The owner is responsible for resolving this matter with the county. Fines will be issued for failure to meet timeframes.
John, for our folks downtown that are doing the recording, can you state your name and position? Again, they weren't sure who was talking there.
John Beavers, Environmental Investigation Supervisor.
Thank you. Gentlemen, I guess my biggest question, I'm sure Counselor is going to explain to me about the neighboring folks around this when they get up there. But is there a reason why we're giving them an alternative to submit plans and obtain a permit on public land that's not part of their property?
Sir, so for this one, it's kind of, the recommendation's kind of, it's option 1 and 2. Option 1 is just put everything back to natural state to include the back area for the public lands, but that's also removing all the additional parking spaces and making sure everything's properly marked. That's option 1. Option 2 would be they can submit commercial construction plans, but that's just for the additional parking. It's not for the impacts on the public lands. No matter what, they have to remove the public lands. They won't get permitted for it, but they can submit the plans for their additional parking. They're just gonna have to change the design. So that would be part 1, and then part 2 would be the attain.
Makes sense, Wayne.
Thank
Okay, so it really is an and, it's not an or. They need to remove all the fill material on the impacted public lands, remove the parking spaces. Oh, I see what you're saying.
Okay.
The first statement combines both.
Yes.
Okay. Okay, yeah. I think if we stick an and in there, then I'm okay. All right, that makes sense.
And I did speak with the representative of the owner for the first time 2 days ago. So I believed someone was going to be here, but they didn't show up. So.
Understand. Okay, all right. Counselor, what would you like to add?
Can we go to the site plan?
We sure can.
And also, Ms. Gay, I emailed you some documents that I was going to present as evidence 2 days ago, 2 or 3 days ago. I also have a hard copy of them if necessary.
It's not on your phone?
No.
Okay.
No.
You want to pass them around, that's fine.
I don't think you'd want my phone.
Well,
All right, well, let's, is the site plan up?
it's working on it. It's
All right.
on some computers, so.
And what I want to do is I want to present, part of my presentation is I said, I represent the, well, I'm going to need them to kind of reflect.
Oh, okay, that's fine.
Sorry, Ms. Gay. Is to kind of, two of your factors as you make your decision is the gravity of the violation and the action taken. And there's been no action taken, obviously.
Sure.
But what I'd like, in addition to the fill and the construction of parking on the south side of the property, if you see on the north side, where there's parking there, but there's the indentations, that, has gone from impervious to pervious. And what's happening is my neighbors are they own the property to the west or to the left of that red boundary line that's running north-south. The flooding there is incredible. Now, it isn't necessarily all because of this, but my clients are trying to fix the problem. They can't fix the problem until this fill has been removed because it's exacerbating the situation. Likewise with all the pervious, because they covered in that impervious to the north side and all repaved all of that. So the 120 days and what's been recommended is, we would really like to see that shortened up. We have reason to believe that the property might be sold. I don't know how long, at what point they record the orders here so that it becomes a lien. But my concerns is if this property sells and there's no recorded order yet, it's all going to fall through the cracks again. And then my client's going to continually get flooded.
Understand that, but understand my position, Counselor. I can't turn around and tell somebody to do it in an amount of time that's not realistic because somebody might be selling the property. At the end of the day, if they sell the property, then we'd have to recite the case against the new property owner and go through the process again. I mean,
But you know how human nature is. They just wait till the 119th day. And in that time, we're coming up on rainy season and my client's going to continue to get flooded.
Now, I
want you to
completely understand that. Yeah.
And
But,
maybe
but,
that could
but
go
the
towards
outstanding
fine.
what if they're going to sell the property, I can't incorporate that into my timeline. if that makes
Understood, but
sense.
maybe we can reflect it in the fine then.
We'll continue on and we'll see how it goes.
I take it, Ms. Gay, we're not able to, were you able to bring those documents up?
No.
All right. Well, one of the things I'm going to show you is, that I'll present to you is the site plan from back in I believe 85 says any additional impervious area shall require retention. There's no retention on site here for any of this water. And in fact, that's another thing I want to point out. To the south of that yellow area and along portions of the east side is, I believe, they're drainage channels. I don't remember what letter it is. And with that new impervious, that's keeping that water from getting into those drainage ditches, into those drainage channels. So, and there's no retention, you know, so they've done all this other work. There's been no retention on site. I do have photographs that show the paving that occurred on the north side. And I do have photographs that show how the road, there's a road right there that's along the, right along that red line that's on the west that floods, and you never know how deep that is. I'll have other photographs that'll show you, you know, how all the parking spaces on the north side are deficient, how where the handicap parking is partially on the sidewalk. And if you, here's another view, and again, I'll give you the opportunity to look at it. You can't, if someone's in the handicap, you can't get into.
That's going to be a challenge.
9.
Mm-hmm.
Likewise, if you see on the photograph there, the few parking spots that are on the west side of the property, if anybody's in there, they can't park where they built this new parking pad. It blocks it off.
Mm-hmm. Counselor, I'm not going to take away from your time, but if you can give me 1 second to ask a question of the staff. So Wayne, John, the issue here, obviously, it sounds like we have the parking deficiencies covered in our staff's recommendation. We do not, in my opinion, have the drainage or water flow or any potential impacts on neighbors covered under this violation. Do we need to open another case in order to do that?
No, because bringing this back to the original permit, the original site plan,
We'll incorporate all of that?
will incorporate it. So, and if they apply for new permits, they're going to have to go through the review with stormwater and all the other departments. So that's the options here. They no matter what, they have to bring it back to how it was at that moment. And that's including taking away pervious material for the front, for the north section. So they got to go back to the original permit, not just remove the stuff that was in the back.
And that would include the swales and all of that as well, and retention of the water on their property?
Yeah, whatever was on the original design.
Okay. All right. Great. Excellent. Thank you.
Ms. Gay, I think I'm ready to hand these over to you now.
Could be one of my last chances to get a phone. All right, Counselor, anything else you'd like to add to that?
That's really it. Everything else would be reiterative. I would very much like to, you know, focus and make sure the record's very clear and the special magistrate's aware that the impact on my clients, especially flooding wise, and as we come into the rainy season, is significant.
I did want to let you know, that didn't occur to me until afterwards, and the folks here on staff made me aware that after I rule my order, we can, as soon as I sign it, we can record it.
That would be wonderful.
So
I would appreciate it.
that would definitely help with your timeline issue.
Thank you very much.
Absolutely.
Thank you for your time.
Sure. Okay, John, can you head back to the recommendations here, and then do we have talk to me about the timeline. Are we concerned about, we've got 90 days for option 1, and then construction plans for 90 days, and then 210 days to complete work?
Yes, sir.
Okay. Is that in excess, or is that comfortable based on what, I agree with Counselor here. I really don't want to give them more time than we.
We could recommend 60 if that's what
Okay.
you'd like to go with.
Especially if we're not getting, do we have any response from the owner about any of this? Any communication with them whatsoever?
The representative, a lawyer that's out of the country, called me 2 days ago for the first time. And they were talking about wanting more time, continue. And I just said, the hearing's set, you can come state what you need. And they didn't show up.
No, that makes Counselor's argument of the 119th day even more valid, in my opinion. So
The
Yeah,
reason we
let's-
have the timelines is because of permitting, if they go that route.
Understand. Regardless, remove of fill material. What if we broke them out and made restoration of all of the materials on public lands within 60 days? I guess that, and removal of 8 parking lots still runs into the same problem. Okay, so let's revise it to 60. And we'll give them 60 days to submit the plans because that doesn't impact the permitting process. And then we'll leave the 210 for the permit. But let's try to move this along on the front end.
Sounds
Make
good.
sense?
Yes, sir.
Okay.
Yep.
All right. You're okay, Wayne?
Yep, good to go.
Okay. All right. Okay. I rule in case L227747 that based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the gravity of the violation, the action taken by the violator and the violator's history, concur with staff's recommendations, require the violator to remove all fill material, gravel, unpermitted asphalt on the impacted public lands and restore folio 024168-0220 to the approved commercial construction plans, including removal of 8 parking spaces and properly mark original spaces within 60 calendar days. In addition, violator has the opportunity to submit commercial construction plans, remove all fill material, gravel, unpermitted asphalt on the impacted public lands. No, that's exactly what we just given them the opportunity to do. I don't like that. What am I missing here?
Submit the commercial construction plans would be if they want to change the original design. No matter what, they have to do that, and they have to remove everything from the impacted public land section. So no matter what,
Okay.
they have to remove whatever's on public lands because they're not going to get permitted for it.
I just want to make sure it reads correctly so they don't assume that they're going to do one or the other. The or is what's bothering me. The first section of the recommendation, we're telling them they have to remove all the gravel, asphalt, impacted public lands to the approved commercial construction plans, including removal of parking spaces and properly mark original spaces within 60 calendar days. That's on their site, bringing it back to what was originally permitted.
Yes. So would it be better if we add like option 1 to that?
Right.
And then add
think that's-
option 2 to the part 1 and part 2?
Yeah, I think that's option 1. And then option 2, submit commercial construction plans, remove all fill material, gravel, within 60 calendar days.
We can put submit commercial constructions plans to alter the approved plans on record. Or
Submit commercial construction plans to alter the approved plans currently on record within 60 calendar days.
and remove all the material unpermitted asphalt on the impacted public lands.
Yeah, I think number 1, I think we should break them apart. I think everything with the public land should be by itself. This you have to do. In addition, you have the option of doing the following. You can either remove the parking spaces, mark the proper original spaces, or you can go through the construction process plan and submit plans and obtain a permit for that work with a certain timeline. Counselor?
One quick question, because I hear both option 1 and option 2. It's always about removing the material off
The public
the
land.
impacted public land. I
Correct.
haven't seen where it's removed that material from the site.
That's in part 1 also.
And I'm just here in public land, and I want to make sure it's clear, because I'm afraid they're going to say, oh, we only had to remove it from the public lands.
Yep.
So I want to make sure that it says and that it's clear that it would be removed from the public lands and the site itself. That's just the only comment.
Yeah. I think the motion needs to, I'm going to read it as I go, so if somebody else can, I guess it's recorded, so we're in good. I think staff's the recommendation that I'm going to recommend is that step 1 is that the violator must remove all fill material, gravel, unpermitted asphalt on the impacted public lands and restore on the impacted public lands. That's statement number 1. Then they have the option of either removing the fill and restoring to the original commercial construction plans, including removal of 8 parking spaces and properly marked original spaces within 60 calendar days. Or they have ability to do that by they can also choose to submit plans and remove all of that material and unpermitted asphalt and fill on their site within 60 calendar days and obtain a permit. Does that make sense? I think you and I are on the same page. Yeah. Does that make sense did I say that properly?
I think that's the intent.
Okay.
And if, it's a matter of, it sounds like they're over their property line, there's a trespass, that needs to all be
Yeah, that just needs
dialed
to
back
happen.
in.
There's no option.
No
for
matter
that.
what.
Correct.
And if they want to, site improvements, that's going to require a subdivision construction plan or a commercial construction plan.
Okay.
So,
All right. So one more time, a little clearer. And then if you have trouble when we're doing the orders, just let me know. But my recommendation is going to be that the violator step 1, remove all fill material, gravel, unpermitted asphalt on the impacted public lands, period. That's step 1. Step 2, the violator has the option.
Need a deadline for that.
Within 60 calendar days. Thank you. And then, in addition, the violator has the option of the following. Either they can restore their folio 024-168-0220 to the approved commercial construction plans on file, including removal of 8 parking spaces and properly marked original spaces and any removal of unpermitted fill within 60 calendar days. Or the violator may choose to submit commercial construction plans and remove all fill material, gravel, unpermitted asphalt on their property within 60 calendar days, or obtain a permit and complete work within 210 calendar days. Owner is responsible of resolving this matter with the county. Failure to meet any of the timelines listed above will result in a daily fine of $300 per calendar day. Make sense? Okay. All right. So ordered. Okay. Excellent. All right. Great.
Thank you.
Thank you, gentlemen.
In that order, there's a good chance that can be recorded with.
Oh, let me add that to my statement also, that once I execute the order, to have that recorded immediately, so it's on file with that particular folio number moving forward.
Thank you.
Absolutely.
Did you provide an address for yourself on the sign-in sheet that we could send you a copy of the order when it's done?
Yes, I did. A mailing
Okay.
address?
Yes.
Excellent. Thank you.
Thank you very much. Thank you.
Excellent. Next case, please.
Page 10, under Public Works and Public Utilities, number 18, case number ROWV-23002. The owner is Kenneth G. Underwood. Location 3613 Danny Bryan Boulevard. We have service and we have someone signed in for this case.
That you, sir? Come on up.
Hello, raise your right hand, please.
Yes.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And state your name and address.
Kenneth Underwood, 3613 Danny Bryan Boulevard, Tampa, Florida, 33619.
Thank you.
Thank you. Good afternoon, sir.
Good afternoon. Do you hear me?
I can.
I'm Ricardo Carnero, Capital Program, Right Away Public Work, 2310 Regional Water Lane, Tampa, Florida, 33619. This is a case of violation right away, ROWB-23002. Violation address, 3613 Danny Bryan Boulevard, Tampa, Florida, 33619. Violator name, Kenny G. Underwood. Violation observed, unpermitted boulder within the county right away. Ordinance section violate, AC section 92-22 of Hillsborough County right away use procedure manual. The first inspection was April 12, 2022. The first notice of violation sent was April 13, 2022. The second notice of violation, May 4, 2022. The first mailbox post, November 3, 2022. The second mailbox post, March 14, 2023. Last inspection was May 2023 and total inspection 6. The first picture, not yet. The first one is a Google Map 2018 without the border on the property. This is was inspecting April 12, 2022 with the border on the utility area. The same day, the same picture, you can see the border. Was posted on March 14, 2023. This is the copy of the notice of violation that was posted, with appear all information about the violation and the people that need to be contacted on the county. The staff recommendation, the homeowner must be removed existing border from the county right-of-way area and then restore damaged one if necessary. The remedial work must be completed in 30 calendar days.
Okay, Ricardo, I'm sorry, but you're gonna have to explain to me the recommendation. So he has to remove the boulders, but he has to restore damaged ones?
That's mean with when they remove the boulder, if the damage of the ground or the grade or the sod need to be replaced, is it necessary?
I see, you don't want big holes lying
exactly
along the
need
right
to be
of way.
restored, yes.
Okay, and just because I'm curious, because I can imagine that Mr. Underwood's going to tell me why he has boulders in the right of way.
I understand.
What option does a homeowner have to prevent damage to the right of way of which the Hillsborough County resident is expected to maintain?
All that I know, sir, is the county don't accept nothing there to prevent that the other vehicle damage the grass. It's not accepted, nothing there.
And is the reason that it's not allowed there because the Hillsborough County needs access to that right of way at any time and that they can't have the
That's
boulders
correct.
there?
It's not allowed. Basically, the utility company need to use the area, and they don't accept that nothing like that be there. And also, the boulders are so close to the edge of pavement and could be have an accident. This is the both reason in this case.
Okay. Mr. Underwood,
Yes.
what would you like to tell me, sir?
Excuse me.
Although I have a feeling I already know.
Yes, you spoke for me.
Sorry.
I'm sorry.
I'm not supposed to testify on your behalf, but I've seen this happen before, so I'm curious, just as curious to as a solution as I am.
And that's what I'm here for, a solution. I don't want to fight it. I don't want to argue it. I'm just looking for a solution.
Tell me what's happening.
I've been here at 3613 for 28 years. And for 27 and a half of those years, I've had landscaping. I grew up, little story. I grew up my great grandparents came from the Cayman Islands, so I've seen manicured yards. I've seen tropical plants, and from my great grandparents to my grandparents to my mother. Now I'm a homeowner myself, so and that's what I wanted. So I think we came up with a date as of 2018. There was no boulders there, and that's correct. But I have some pictures, if I can present.
Are they on your phone?
Did put that. No.
Okay, absolutely. Then you can pass them on to my folks here to your left.
I've seen enough
Mr.
judges
Chris, come get 'em.
not to move.
No, you're one step ahead already.
Yeah, so. And that's just one occasion. There was a homicide on that same street 5-6 years ago. And the sheriff department, and I understand this, the sheriff department had to come and investigate. So everybody's yard was tore up because they parked all over the place. But school buses, kids with dirt bikes, you see where the sidewalk is coming to the street, where the humps, bumps of the skids. Mm-hmm. There was a car, before I had that Bismarck palm planted there, a car went up.
Into your yard, straight through the corner.
Yeah, and my bedroom is right behind that Bismarck, but but they make wide turns and they get up on the right of way. If I could throw some figures out, I've been there 28 years. The average of $200 a month just on landscaping, another $60 a month on every 6 weeks, not a month, on fertilizing, treatment and stuff like that. I invest a lot of money in that property right there. So try and protect it, so I know that's the county part, but I'm responsible for taking care of the county area of the right of way. So again, not to argue it, not to fight it. I just need what can I do? What should I do?
Right.
Yeah, that's the only thing. And I was surprised that I got even a warning, a notice about some boulders. You go to Sarasota, they all over the place. Mansions got boulders out to protect some areas here. So I'm a little surprised that I'm here. And I apologize for being uncomfortable. But I know,
you're fine.
I don't know.
Let's take it back to the staff. So, yeah. Ricardo, what deterrents or landscaping or things are allowed within the right of way for them to be able to protect the right of way as it is?
All that I know is nothing is acceptable. Sometimes the people using the plastic reflector is not acceptable. Nothing there is acceptable. That's the orientation that we have Development Service Department, so that's me.
They have parties, the neighbors, and their guests. Their guests park, I'm talking about all 4 tires up on that. And it's a little uncomfortable for me to go and knock on their door and ask the owner to have their guests to move. Pretty soon they're going to be confrontational, and I don't want that. And I want everybody to have a good time, but not at my expense. Having a resort, having to fill back in.
We had a case a couple of years ago where we had an issue, something similar, but Verizon had access to that right away. And I thought we had the opportunity for the homeowner to sign something or say that if the right of way needed to be used, that it was the homeowner's expense to remove the things that were put in the right of way. And then I guess my follow-up question is, can he plant something in the right of way? I mean, can he find Florida, approved street trees and because we do currently plant street trees in the right of way.
If he's going to do that, he need to apply for right of way permit for natural resource permit too. So maybe it's an auction, but all that I know, Development Service is not accepting nothing about the for protecting, put it there in the, like the boulder, like the zone sign.
Since we have natural resources here, John, are we barking up the wrong tree here?
No, not at all. I mean, this is probably maybe an older subdivision that's grandfathered without that requirement. I know that there was past, we would, that was part of our permit to mention that you would have to apply for a right-of-way use permit, but we've been told by right-of-way that that's not necessary anymore. So, yeah, there's street trees that are required in new subdivisions. We would not have any objection to that.
Okay.
Excuse me. I've heard of previous cases on trees. I don't want to be part of that.
You don't want to what?
I don't want to have anything to do with trees. The previous cases.
If you have somebody cut them down illegally and then toss them into the water behind your house, then obviously there's some issues there, right? So this might be a little different.
Yeah, I know about oak trees. You can't touch, trim, or without a permit.
No, but I guess where I am, sir, is I understand the Hillsborough County ordinance, and I swore an oath to uphold that and upstand that. So,
I just
by the same token, as a resident of Hillsborough County and having personal history in something like this,
yes,
it sounds like there might be a way for you to go through natural resources, even if a right-of-way permit is not required. I bet you that John could give you his business card and you two could work offline on trying to, I know it's an additional expense, but it creates a permanent solution for you to be able to prevent people, especially if you're on a corner and cars are heading towards your house and things like that. It's also a safety issue.
So I noticed you had maybe some Bismarck palm or some sizable palms on your property. I mean,
yes,
you put a few of those out there. There's not, that's a pretty
But on the
bulky
right-of-way?
sized palm.
on the right of way.
In between the lot, the curb and the sidewalk.
Yeah.
That'll get their attention.
Again, I'm not trying to,
I don't know what to do.
I'm not trying to increase your costs here, and I know you've been maintaining it for 28 years, but I'm trying to make sure there's a creative solution for you so that you don't just remove them and
But
go
the
back
boulders
to
has to come up.
what this is.
Yeah, the boulders have, and I don't have any problem with
Yes,
that.
sir.
I just don't want to. When I move them, then that starts all over again.
Yep, absolutely. So my suggestion is, my recommendation is going to be for this particular case is I'm going to give you some extra time. And by extra time, I mean a significant amount of extra time.
I can get them up
So
this
that
weekend. Yeah.
I know you can,
Yeah.
but I prefer that you have time to go with
Okay. Yes.
solution B,
Absolutely.
and then you can remove the boulders once you've completed your work.
Okay. Okay.
That way, this doesn't happen in the interim, because then it's all for naught.
Yes. Absolutely.
So I'm going to give you 180 days
Okay.
to complete the removal of these boulders.
Okay.
And then there'll be a fine if you don't do that, but that's 6 months.
Yeah. Okay.
So within 6 months, I think, should be able to come up with a solution again, and I'll have the folks from Natural Resources give you a card
Sure.
and just offline go and talk to them, get in touch with them and talk to them about what makes sense.
Okay.
And they'll give you a list of street trees. You can go and price them, figure out what the most economical option is for you.
Sure.
And then you can get that done before you remove the boulders.
Okay.
And then all I ask is I gave you a significant amount of time to remove the boulders. So if you get the project done early, you just give Ricardo and his team a call. They'll come out, verify that it's complied, the boulders have been removed, and then you're in compliance moving forward. Okay, sir?
Yes.
Okay, all right.
Thank you much. Thank you much.
Absolutely. Okay, so let me go ahead and do my official side of it. I rule in case ROWV 23002, the basis is presented. I find the property is in violation of Hillsborough County Codes of Ordinances listed in staff's presentation. Further, based on the gravity of the violations, the action taken by the violator and the violator's history, grant 180 days. I concur with staff's recommendation to require the homeowner to remove the existing boulders from the county right-of-way area and restore the property to its original condition if necessary. I grant the homeowner 180 calendar days to complete the work. That's my motion. That's it. And then, like I said, just stay in touch with them, go through the process offline and figure out the right way to get that done.
Okay.
Okay?
Sounds good.
All right.
Thank you much. Thank you for your time.
Yeah, I will, yeah, technically I have to put a fine on the 180 days. Failure to meet any of the 180-day timeline resulted in a daily fine of $50 per calendar day. So,
You don't have to worry
but
about
you're going to be way ahead of that, I feel. Yes, sir. Thank you very much for coming in and explaining it to me. I appreciate it. Absolutely. Have a great weekend. Next case, please.
Yes, the next case ROWB
No,
23006.
hold on.
Hold on, she's got to
Hold
announce.
on. I gotta
Okay.
do my thing.
She's got her part to do.
Do you want me to do his
Sorry.
next one? Or do you want to go
Are
back?
are there only two? Yeah, let's go ahead and knock out the other one.
Okay, we're going to go ahead and do number 19, ROWV 23006. The owner is Sheila Olivo, 5006 Cumberland Drive. We have service and no one is present.
Okay, sorry, thank you. I'm Ricardo Carnero, Capital Program, Right Away Public Work. This is the case of violation right away ROWB-23006. Violation address 5006 Cumberland Drive, Tampa, Florida 33617. Violator name Sheila Olivo. Violation observed, unauthorized water discharge. The property owner have pipe encroachment that is pumping water within the county right away. Ordinance section violate AC section 92-22 of Hillsborough County right away use procedure manual. The first inspection of the property was September 23, 2021. The first notice of violation, September 27, 2021. Second NOB, November 9, 2022. Mailbox NOB post, December 13, 2022. Last inspection to the property, May 8, 2023. Total number of inspection, 5. The first picture is the picture of the Google map of the property 2017 without any pipe encroaching the county right away. The next one is a video of September 2023, September 23, 2021, showing the pipe discharging over the county right away. Do you see the video there?
I see it. I'm not quite sure what I'm looking at yet, but I'm hoping the next one explains. That's coming out right by the
Yes.
mailbox? Underground?
Underground,
And
yes.
it's coming from the house?
From the house, yes.
And what is the discharge? I'm afraid to ask.
If you see in the next picture, December 13, 2022,
Not yet, but
not yet. You can see the pipe from the property under the ground discharging on the county right away. So the inspection, December 13, 2022, was the pipe there.
what is that? Is that the condensation line from the air conditioner?
I don't think so. Maybe it's a pool.
That's an awful lot of water.
Maybe it's anything else inside, but we don't know. Yes,
Oh,
maybe.
Water softener? Oh, okay. All right. That's a lot. Yeah, okay.
So the next inspection was the NOB post, December 13, 2022. This is a copy of the NOB that was posted with all information and the people that need to be contacted.
Okay.
So the last inspection, May 8, 2023, is still the PVC pipe there.
Okay. Staff's recommendation?
Yes, staff recommendation. The homeowner must be applied for a right-of-way use permit and should be approved within 15 calendar days to restore the area at the original condition per Hillsborough County standards. The remedial work must be complete and the right-of-way final inspection must be approved in a total of 45 calendar days.
Okay, I have a little bit of concern about the wording of the recommendation. So I think what we're trying to say here is the homeowner must apply for a right-of-way use permit within 15 calendar days, period.
Yes, for the permit.
Okay, so not to be approved within, but to apply within 15 calendar days, correct?
Correct.
Okay, and then the homeowner has the option, if approved, the owner has the opportunity to complete the remedial work within 45 calendar days.
It's counting the 15 days plus the 30 days after approved permit to complete with the installation. Because basically they need to remove the PVC pipe and need to restore the grade and restore and put the sub-bath. So they require the permit for do that kind of work.
Okay, but you're not taking into account the time it takes to process the permits.
Correct.
So the total of 45 calendar days is not sufficient. Right? So what you're saying is you want to give them 15 days to apply, and then you want to give them 30 days to complete the work.
Yes.
Okay, so there's that gap in between of them having to actually get the permit.
Right?
Right?
Right.
Okay.
That's
okay.
our idea. The 15 days to get the permit, the other 30 days to do the job.
Okay, all right, I'll just reword it. That's fine. Okay, that makes sense. Okay, I agree.
Thanks.
You bet. I rule in case ROWV 23006, that based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the granted violation, the action taken by the violator, and the violator's history, I grant that the homeowner must apply for a right-of-way use permit within 15 calendar days. Period.
Yes, for example, in this case, the homeowner tried to solve the issue with the county. And they say, we are not using anymore. A development service say, need to remove the pipe.
Got it. Okay, that's the remedial
So
work.
after that, they never contact the county anymore.
I understand. So we need to incentivize them to deal with the county. Got it. Okay. Homeowner must apply for a right-of-way use permit within 15 calendar days, period. The homeowner has the option, after approval of the right-of-way use permit, the homeowner must complete the remedial work and the right-of-way final inspection within 30 calendar days. If the permit is not approved, the homeowner must remove all of the work and restore to original conditions within 30 calendar days.
It's a little confused. But basically they need the permit to do the work in the right way. And also when we approve the permit, is that the pipe is not there, everything is fine. So maybe the next time we are talking about the total 45 days, calendar days, that include the permit and the restoration, everything maybe.
Yeah, I didn't want to do it that way because the permit is the unknown. So it could take a week to get the permit. It could take 60 days to get the permit. So this way, we give the owner 15 days to apply for the permit. And if the permit is approved, they have, after approval of the permit, they have 30 days to complete the remedial work based on the conditions of the permit. If the permit is not approved, they have 30 days to remove everything that's there. Those are the options. So they either are removing it or it got approved by the right-of-way to have it there and they've completed all the work that needs to make the permit happen within the same amount of time.
Basically, the permit will be approved because it's only remove the pipe and restore the damage.
Ricardo, do they have to get the permit in order to do the work that you're requiring them to do? Is that what we're missing here?
Yes, the
So
point
they
is
can't fix it until they get the permit.
sometimes development service decide that, for example, the case before, he can remove the boulder, that's it, no permit. But in this case, he need to remove the pipe under the ground, under the sidewalk. It's different work. So they require the right-of-way permit to do that. They don't need to present the site plan. They don't need to present a lot of specification. Only they need the right-of-way permit.
Okay, so they're not going to be allowed to have this regardless.
approved and need to be inspected and final inspection approved to close the case.
I understand that, but just for my clarification, this right-of-way, what they have there right now is not allowed. And there is no scenario in which the homeowner will be allowed to have that remaining. And the right-of-way permit is just for the removal of what's there.
That's correct,
Okay, got it. All right.
because it's a requirement.
No problem. I
He's-
will
he's
amend
going
I will amend my recommendation. So the homeowner, my new recommendation, the homeowner must apply for a right of use permit within 15 calendar days to restore the area to original conditions per Hillsborough County standards.
That's the reason of the permit.
I understand.
Maybe it should be different, maybe.
That's fine. So they have to apply. I want to make sure they apply in a timely fashion. That's all that statement does. 15 days to submit a right-of-way use permit for the authority to restore the area to original conditions, meaning they're going to have to remove it. After issue of permit, the homeowner has 30 days for which to complete the remedial work and call in the final right-of-way final inspection.
That's correct.
Okay.
Because
Excellent.
basically any work that I told you the last time
Mhm.
on the county right away require permit.
Understand.
Sometimes that kind of work like the boulder, so they decide that they don't do it. apply for
My
permit
error.
for
I was
that.
still thinking you were giving them a chance to get a permit to go back and get something approved that they had done without a permit. So it's not allowed from the beginning. So this is just to clean up their mess.
Good,
Understand?
thank
Okay.
you.
Make sense? Okay. Got it. So moved. Next case, please.
Okay, that was all of the right-of-way cases.
All right. Thank you, Ricardo.
Thank you.
You have a great weekend.
You too, thank you.
Turn back to page 6 under landscape and natural resource cases, number 10, case number L227369. This case was pulled per staff. Number 11, L227470. The owner is
Go ahead.
I can't say it. Last name Ekicha, Cassandra and Udocchukww, whatever. I'm sorry, I can't do it.
No problem.
The location is 6612 Thaxton Drive. We have service and no one is present.
I am present.
There's a young lady on the phone, I think.
I apologize. I wasn't aware someone was here.
Yep.
Sorry, Miss Cassandra. How do you say the last name, please?
Please.
My husband's name is Udocchukwu, and our last name is Ikocha.
Ikocha. Thank you.
I apologize for messing it up so badly. Raise your right hand, please, ma'am. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name and address for the record, please.
Sure. Cassandra Ikocha, and it's 6612 Thaxton Drive, Riverview, Florida, 33578.
Thank you.
John Beavers, Environmental Investigations Supervisor with the Natural Resources Unit, Hillsborough County. This is case L227470. Owner violator Udocchukwuka and Cassandra E. Koshia. Violation address 6612 Thaxton Drive, Riverview, Florida. Violation observed. The investigation found that a fence had been installed in the backyard of the property that is within the 30-foot wetland setback. Ordinance violated section 4.01, first inspection June 9th, 2022, first notice September 7th, 2022, last inspection April 27th, 2023. Inspections conducted 4. Turn this over to Tony Hood.
Good afternoon, Tony Hood, Hillsborough County Natural Resources. Are you able to see the photographs?
Yes. Miss Cassandra, can you see the photographs?
Oh, yeah, I can.
Okay, great.
Perfect. We received a complaint that a fence had been installed in the wetland setback. The red line is the approximate wetland line, while the blue line is the approximate wetland setback line, and it shows that the fence is almost entirely in the wetland setback. This photo was taken June 9th, 2022.
Okay.
Here is a photo taken from the property appraiser's website, dated December 4th, 2022. It's an aerial. Again, the red line showing the wetland line, the blue line showing the wetland setback line, and the aerial shows the fences within that setback.
Okay.
Here's a plat dated January 11th, 2021. The property is circled in red, lot 35, and the wetland line is shown in red.
And the other dashed line is the wetland setback line,
No, that's their.
the actual property
Yeah, it's like
line?
36 feet. It's 6 or 38 feet. It's 8 feet off of that.
Okay.
Next slide. This photo is a recheck taken April 27, 2023, showing in the distance that the fence is still present.
So on L 227470, staff recommendation, part 1, remove all fence materials from the wetland setback conservation area within 120 calendar days, or submit and obtain a variance decision within 120 calendar days. If a variance is approved, code case will be in compliance. Part 2, if a variance is not approved, remove all fence material within 30 calendar days of denial. The violator is responsible for resolving this matter with the county. Fines will be issued for failure to meet timeframes.
Okay, Ms. Cassandra, what would you like to add?
Well, I've talked with Tony before. We obviously, I have had him come through and, walk the back property with me and even did measurements. I don't, and of course I know now that there was an ordinance there. When we moved in, we did not know that there was one. We went with a reputable, like one of the top 2 fence companies in the area, recommended by a neighbor. We were told there was no restriction from the county. From them, we submitted through HOA, did everything right. I'm a realtor as well, so this is like an extra layer for me that this is even happening. Of course, we put in the 4-foot slotted, thinking there was like a 10-foot setback because there is water. And it was not a cheap fence. The aluminum fence is top dollar. So we were actually, stretching funds to make it happen to begin with. The reason that we even put in the fence wasn't just for our like aesthetic purposes. We actually have 2 dogs. They're often used for military. They're called Belgian Malinois. They look like shepherds, and they are friendly. They don't have any bad track record, but we have elderly neighbors. We also have another neighbor that has like cameras and it has small dogs and is just very nervous. So from the time we moved in, we kind of had the feeling that they just were not super comfortable with our dogs just being around in the backyard. So at some point, we actually had a new neighbor move in with a puppy. The puppy came over into our yard to say hi to our dogs, and that just kind of made everybody a little bit more layer of nervous. So to avoid any bad situation happening, we decided we'd go ahead and put in the fence. So at that point, that's when we cleared it with everybody. The fence company said it was okay. HOA approved it. We put it in, and after a while, I guess we got the notice from the county, and we thought, well, there just must be a mistake because we did it the right way. And even our neighbors, like probably 6 of them, because we walk our dogs all the time, we're like, wow, we love your fence. We want to do one. That looks so beautiful, this and that. Like, we've not had one person come up to us and say we don't like it. So I know Tony gave me the name back in the day of whoever complained. It's definitely not one of our neighbors. I believe the address they even put on there was like a generic one of our clubhouse. So I don't think that they're present today. But anyway, say all that to say, I mean, I have had Tony out there, and I don't see there's any issue with any sort of like it impeding water flow. There isn't any, or it obstructing any sort of nature, or I mean, arguably it's like saving nature's life, because my dogs can't attack a duck. They all walk around it, so they're just, if anything, it's just been a huge relief for us and for our community. So, you know, we didn't want to, we wanted to be able to exercise some sort of alternative, you know, just trying to do research and figuring out that there was a variance. It seemed like nobody even applies for variance for a residential instance like this. And of course, it's not cheap either. I know it's like a few $1,000s even just to get like your case heard, and then they can just say no, which from what I heard, it's a very common occurrence. So we've already spent, you know, $5-6 grand putting the fence in. And we were also told by the fence company that this has never happened. They've put in the same type of fence in the same scenario. Nobody's ever complained or reported. And also that it was going to cost another couple $1,000s at least to even have it removed. So we didn't have the funds, and we didn't even understand how it was a real problem. So that's why we're here right now. So would love to come up with a solution that would, you know, help us. One of our dogs is a emotional support animal, and we just, I mean, it's not an option. Of course, they're like our kids. We can't get rid of the dogs. We don't have the funds or ability to even sell or move the house. So we're just kind of in a catch-22, I think, with this whole thing.
I totally understand and appreciate trying to do the right thing for the right reasons. And unfortunately, this is just the way the code reads. I know you've already been in touch with Tony and in regards to the variance process. I would, being in the private sector life, I've done some variances in the past. I mean, you might have a bad taste in your mouth from some folks that haven't had it done or done properly, but it can be done. I wouldn't say it's all no's, but you're right. It is, you know, spend a bunch of money and then you're in the hands of somebody. But I believe that you have valid reasons for why you're doing it. So I would encourage you to at least consider going that route. The options that we have here today, unfortunately, from a code standpoint, are really the ones that they've discussed. So you have the ability to take it out. And I know there's a cost associated with that unless you take it out yourself or whatever, or you have the ability to go through a variance process, and you have some time in which to do that. And I can give you some extra time to, you know, get through that process or, you know, put away some more money, unfortunately, to go through the process A or B to get it completed. But my hands are kind of tied on I don't have the ability to say that it can stay, unfortunately. So
yeah, it's
no.
unfortunate. I'm sure there's 1,000,001 cases where this goes unreported and everybody's happy, but unfortunately, somebody walking along the street or driving by just happened to bring it
Right.
up. So I understand your situation as well.
Yeah.
It's just, it's just horrible. Is there, if we do go the variance route, and I know I've kind of asked Tony this before, if anybody knows, while I'm on the phone, I've been listening to all these other cases all day. So if there is any sort of other alternative to a fence, I mean, I don't think there is one because of knowing my dogs. But like, I was trying to get even creative. I'm like, look, I'm not just trying to, you know, be stubborn. Like, if there's another alternative, like, they will not even stop for an invisible fence. Like, they would go straight through it. So, I mean, I've talked about doing like thick hedges or something. Like, I'm like, what's a non-permanent structure? I was like, I mean, this is, I guess, arguably a permanent structure, but if there's any that you've heard of that people do, I mean.
Yeah, Ms. Cassandra, it seems to me I've seen that done in the past where somebody's done hedges or some sort of trees or something. I'll turn it over to John to give a little more detail, but based on the size of your dogs and those kind of things, I don't know if that's, you have to put them really close together, I guess, but I don't know. John, what do you think?
At least it might help with the visual, like they won't be like looking at a dog or something, and it might mitigate it. But, you know, of course, I understand the county, you know, the law says that the dogs are my property. So if God forbid something were to happen, you know, I don't want to be put in a situation where, you know, it's not their fault, it's not my fault. And, you know, now somebody's, you know, complaining for a worse thing than a fence.
Totally understand.
Yeah, I was just going to add that we would support, you know, some hedges, you know, the right, you know, Florida friendly landscaping and some native hedges back there. And we could provide you with a list of that, and maybe some other supplemental landscaping that would create at least a visual, you know, barrier, and also, you know, supplement the setback itself. So.
Okay. Yeah, and then the variant, I don't know if that's something I could ask again later, what the cost of that would be, because that would be potentially us doing that and getting denied, and then also paying for fence removal is just, that's a lot. So we're just, it's not the best of time financially for us either, so it's a risk. Nervous about
Absolutely.
it, but
And if I can give you one piece of advice without my hat on, I would say that be sure to do your research in regards to those that assist with the variance process. There are several folks in Hillsborough County that have a really good track record. Obviously, I'm not biased, so I can't give you specific names, but a simple web search will get you to the right people to have a consultation with, and they should be able to give you, at least a percentage of success kind of thing to help you, make that financial decision. So I hope you at least, take a look at that. So, but from a staff recommendation standpoint, we can give you the timeline to get these things done, and then you can make that choice within the next 120 days in regards to which direction you want to go. So that gives you some time. Actually, I'm going to increase it to 150 days just to give you more time to either fundraise or make that decision. So it's already there, so you're not impeding anyone, and there is a timeline associated with getting it either removed or the variance approved. So I think 150 days is fair.
Okay, thank you. Is the variance, once that started, is that part of that calendar time? Because I just don't even know how long that process would take. Is that something that?
So the 150 calendar days will also apply to the variance. If you run into an issue where you're in the variance process and you're still without time, you just stay in touch with the folks at Natural Resources. And again, if the variance is approved, the violation goes away. So it's in everyone's best interest to wait for resolution on the variance if you go that route. So you just stay in touch with them, but because nobody knows, they could have a docket that goes 6 months. I don't know, but yeah.
Okay, that's what I was wondering. And then lastly, I guess my only other question is, when you're saying there are certain ones I might be able to find to maybe hear my case a little bit louder, would I be able to request a certain person, like for the variance that I could potentially have a better?
What I was referring to, there's private individuals that basically are consultants that you can hire to work through the process with you. And there are some very good ones out there. So yeah, if you do a little research on that for Hillsborough County variances, you should be able to find some folks that do it on a regular basis. And I would, based on the result that you're looking for, I would definitely try to find someone that's had a good degree of success, and they'll consult with you and give you an idea, how they think it might go.
Thank you.
Absolutely.
All right,
No problem. Yep, absolutely. I will go ahead and rule, and we'll move forward from there, and just stay in touch with Tony through the process. Okay.
All right.
And I wish you the best of luck.
Thank you.
No worries. Thanks for coming online today. Have a great weekend.
You too.
I move in case L227470 that based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances as listed in staff's presentation. Further, based on the gravity of the violation, the actions taken by the violator, and the violator's history, I concur with staff's recommendations and require the violator to either Part 1, remove all fence materials from the wetland setback conservation area within 150 calendar days, or submit and obtain a variance decision within 150 calendar days. If variance is approved, code case will be in compliance. Part 2, if variance is not approved, remove all fence material within 30 calendar days of denial. Violators responsible for resolving this matter with the county. Failure to meet any of the timelines listed above will result in a daily fine of $100 per calendar day. Okay, Ms. Cassandra, you're all set. Thank you very much.
Thank you. Bye, guys.
Bye-bye. Next case, please.
Page 7, number 12, L227697. The owner is Autumn Project Development LLC, and the location is a vacant residential lot northeast of Dale Mabry and Bears Avenue. Folio number 01642600000. We have service and no one is present.
John Beavers, Environmental Investigation Supervisor, the Natural Resources Unit. This is L227697. Owner violator, Autumn Project Development LLC, violation address folio 016426, Tampa, violation observed, unpermitted removal of protected trees per LDC section 4.01. This property is in violation for 121 inches DBH of tree removals consisting of live and laurel oaks, maples, and sweet gums. Ordinance violated section 4.04, first inspection December 19th, 2022, first notice December 19th, 2022, last inspection April 5th, 2023. Inspections conducted 3. Turn this over to Inspector Wayne Doyen.
Wayne Doyen, Hillsborough County Natural Resources. Got this complaint. I did a little research before. This is an aerial from Property Appraiser, and I circled the approximate area of tree removals. Next slide. I left a notice of visit at the property when I first went there. This is from a adjacent property that I took the picture on December 19, 2022. Actually, I took that picture before. I did meet on site with the property owners on December 19, 2022. They allowed me on site to measure the stumps that were remaining because all they did was cut to the ground. So all stumps were remaining at the time. Next slide. On April 24th, 2023, I made a recheck, no activity and no contact since that December meeting that I had on site with them. So after measuring, it came up to 121 inches of trees that were removed.
So in L227747, staff recommendation,
Wrong one,
remove
John.
all. Right. Case L227697, staff recommendation, donate 121 inches DVH of approved shade tree restoration trees or contribute $7,865 to the restoration fund or a combination of plantings, donations, and contribution to the fund within 90 calendar days. Trees must be 1 inch DBH or larger, a minimum of 8 feet in height, Florida grade number 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per DBH inch. The owner will be responsible for this violation. Fines will be issued for failure to meet timeframes.
Wayne, you were able to get on site, and so none of this is estimated. This is all exact to the stumps?
No, my original visit when I left my notice, it was that was done by a tree survey, which was off. So I scheduled that meeting with them on December 19th. We met out there and measured the stumps, and this was absolutely correct amount of inches, and they were good with it. But they've been in silence ever
dark.
since. Yep.
Okay. All right. Excellent. Thank you. I rule in case L227697. Based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the gravity of the violation, the actions taken by the violator, and the violator's history, concur with staff's recommendations require the violator to plant or donate 121 inches DBH of approved shade restoration trees or contribute $7,865 to the restoration fund or a combination of plantings, donations, and contribution to the fund within 90 calendar days. Trees must be 1 inch DBH or larger, a minimum of 8 feet in height, Florida grade 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per DBH inch. The owner will be responsible for this violation. Failure to meet any of the timelines listed above will result in a daily fine of $425 per calendar day. Is that right? Hold on 1 second. I say that. It's late in the day. My math might be off. That's fine. $425 per calendar day.
Okay, ready?
Ready. Next case, please.
Okay, that does conclude the natural resource cases. So
Okay.
on page 9, fire marshal cases, number 16 was a continuance and it was pulled per fire marshal staff. And number 17, and number 16, for the record, FM 22007 was pulled. Number 17, case number FM 21009 was a contest and it was pulled after discussion with the property owner.
Okay.
And that concludes the agenda.
Fantastic. Thank you, ladies and gentlemen. Thank you to everybody online helping out today. We are adjourned.